Chapter 3 Indian laws relating to drafting and conveyancing. First one, Indian Contract Act. Proposals also known as offer. Proposal has been defined as in the act is a proposal is also known as offer. An offer is a proposal by one person whereby they express his willingness to enter into a contractual obligation in return for a promise, act, or forbearance. The person is making the proposal or offer is called a proposal or offeree, and the person to whom the proposal is made is called the offeree. Once offer has been accepted, the offeree becomes acceptor. Essentials of proposal: there should be at least two persons. One person should be express his willingness to do or abstain, and the purpose should be to obtain the assent. Kinds of offers: particular or specific, general, cross, open or continuing or standing. Open, continuing, standing. Counter offer, contract by post or email, and contract over the telephone. And they gave the identify the proposal. First one is counter, second is open or continuing or standing, and third is general offer. Rules governing offer: the valid offer must comply with the following rules. First, offer must be clear, definite, complete, and offer must be communicated. The communication of an offer may be made by words, that is oral or written, or it may be implied by conduct. The communication of the offer may be general or specific. When an offer is made to specific person, it is called specific offer, and it can be accepted only that person. How it can be revoked? How can offer revoked? If by the communication of the notice of revocation, by communication only we made offer, by communication only we revoking, by the lapse of the time prescribed for such offer, and by the failure of acceptor to fulfill a condition precedent to accept, by the death or insanity of a proposer, if the fact of his death or insanity comes to knowledge of acceptor before accepting. Offer and invitation to offer. Invitation offer is a communication to invite certain person or public making an offer. The same may be understood from below mentioned examples: a mere statement of intention, a mere communication of information in the course of negotiation. Communication: an offer that has been communicated properly continues as such until it lapses or until it is revoked by the offerer or rejected by the accepted or accepted by the offeree. Communication. According to section 3 of Act, the communication of proposal, the acceptance of the proposal, and the revocation of proposal and acceptance respectively are deemed to be made by in any act or omission of the party proposing, accepting, revoking, by which he intends to communicate such proposal, acceptance, or revocation. So communication can be for anything: acceptance, revoking. Essential of section 3. The purpose of section 3 is to provide for: first, communication of the proposal, acceptance of the proposal, and revoking of the proposal, revoking of acceptance. There must be an act or omission of maker for acceptance and revocation. The act or omission should intend to communicate such proposal, acceptance, or revocation, or should have the effect of communicating. Completion of communication: when the communication is said to be complete. Proposal: the communication of a proposal is complete when it comes to the knowledge of the person to whom it is made, that is the offeree. Acceptance: the acceptance completes for the offerer and the offeree at different times against the offerer or proposer when it is put in the course of transmission to him so as to be out of the power of the acceptor when it is come to knowledge of the proposer. Revocation: like example for against the proposer is like, if I want to send you WhatsApp message hi, the moment I send hi, the communication is completed. And as against the acceptor, when it comes to the knowledge of the proposer, like we'll read in info whether the other person have read or no. If blue tick is it, that there is a knowledge of the proposer. When he come to the knowledge of the proposer that he has accepted the hi, so that is the against the acceptor. Next, revocation. The revocation also takes place for the offerer and offeree at different times. So acceptance and revocation at different times. Proposal is complete when it comes to the knowledge to whom it is made. As against the person who makes it, when it is put into course. So for both same, for proposer and this first one, when it is put in the course of the transmission, but the bit changes it to the person to whom it is made, so as to be out of the power of person who it is making, as against the person to whom it is made when it comes to the knowledge. By when an acceptance of proposal be revoked. A proposal may be revoked at any time before the communication of its acceptance is complete against the proposer. Means until the acceptor accepts, there is a time to revoke. An acceptance may be revoked. So if seller proposed, buyer accepted, so buyer can revoke when the acceptance buyer may be revoked at any time before the communication of acceptance is complete as against the acceptor. So before it reaches to the seller, I have revoked. Acceptance. A proposal on acceptance become a promise. Every promise or set of promise forming consideration for each other becomes agreement. Therefore, special relevance should be given to acceptance. In order to convert a proposal into promise, the acceptance must be absolute and unqualified, be expressed in some usual and reasonable manner. According to Section 8 of Act, performance of the condition of a proposal or acceptance of any consideration for any reciprocal promises which may be offered with is an acceptance of the proposal. The below clarify the rules relating to valid acceptance. First, it should be absolute and unqualified, expressed in usual and reasonable manner. Performance of the condition of a proposal means preconditions. Acceptance of consideration. Essential of the contract. First, valid agreement should be and free consent. Competency of the parties, that is, parties should not be minor or unsound mind. Valid consideration, lawful object, agreement not to declare void. The process of reaching valid agreement is already discussed. Free consent of the parties. Section 13 defines consent as under two or more persons are said to consent when they agree upon same thing in the same sense. Consent is said to be free when it is caused, not caused by coercion, undue influence, fraud, misrepresentation, mistake. Consent is said to be caused when it would be not have given, but the existence of such coercion means it is not a consent, valid consent. Coercion, Section 15, is committing or threatening to commit any forbearance by the IPC or the unlawful detaining or threatening. So, coercion means threatening is the keyword. To detain any property to prejudice of any person whatever with the intention of causing any person to enter into agreement. Undue influence, where the relations subsisting between the parties are such that one of the parties in a position to dominate the will of the other and uses that position to obtain an unfair advantage over the other. Example, teacher and student. Here it is a good relationship, but any other relation wantedly to dominate, to do the influence if they use, that is a undue influence. Example of undue influence are given. So Ajit employs undue influence. Provides a situation in which it is deemed that one has dominated the will of other. It provides that a particular and without prejudice to the generality of the foregoing principle, a person is deemed to be in a position to dominate the will of another, where he holds a real or apparent authority over the another, or where he stands in a fiduciary relation to the other, where he makes a contract with a person whose mental capacity is temporarily or permanently affected by reasons of age, illness, or other bodily distress. Provides that a provision relating to burden of proof, undue influence. It says where a person who is in a position to dominate the will of the another enters into contact with him and transaction appears on the face of it or on the evidence adduced to be unconscionable, the burden of proving that contact was not induced by undue influence shall lie upon the person in a position to dominate the will of the other. So Amanta, being a debt to Bikrant, the money lender of his village, contract a fresh loan in terms of the appear to be unconscionable. It lies on a Bikrant to prove that the contract was not induced by the undue influence. So who is in authority to undue influence? They for proof of liability also on them only. Fraud means includes any of the following act committed. The suggestion following act committed by a party to a contract or with his acceptor with his awareness or by his agent with the intent to deceive another party thereto or his agent or to induce him into entering the contract. The suggestion as a fact of that which is not true and by the one who does not believe it to true. So there is a fact that is not true. Even I know that is not a true. A suggestion of a false. Wantedly I am saying that is a true. The active concealment of the fact, a promise made without any intention of performing it, any other act fitted to deceive, any other such act or omission as the law specifically declares to be fraudulent. misrepresentation means here the intention is the good, but you mistakenly misrepresented the positive assertion in a manner not warranted by the info of person making of that which is not true, though he believes it to be true. So he is believing it to true, so he shared, but actually it is not true. So misrepresentation, any breach of duty which without an intent to deceive, gain advantage to the person committing, or any one claiming under him by misleading another to his prejudice or the prejudice of anyone, causing however innocently a party to an agreement to make a mistake as to substance of the thing which is subject of the agreement. So subject matter of the agreement only is in mistake. Mistake subject to provisions of section. A contract is not voidable because it was caused by a mistake as to law in force, but mistake as to law in force in India has the same effect as a mistake of fact. Both the parties to an agreement are under a mistake as to matter of fact essential to agreement. The agreement is void. So if matter of fact void, it should be noted that an erroneous opinion as to value the thing which forms the subject matter of the agreement is not deemed to be mistake as to matter of the fact. A contract is not voidable because it was caused by a mistake as to law in force, but mistake to a law not in force in India has the same effect as mistake of fact. Consequence of agreement being vitiated by coercion, undue influence, fraud and misrepresentation. When consent is caused by coercion, fraud, misrepresentation, the agreement contract is a contract voidable at the option of the party whose consent was so caused. However, a party to the contract whose consent was so caused by fraud or misrepresentation may, if he thinks fit, insist that the contract shall be performed, means he is okay with that, so, and that he shall put in the position in which he would have been if the representation has been made true. If consent was caused by misrepresentation or by silence fraudulent within the meaning of section 17, the contract nevertheless is not voidable. It is a misrepresentation, so not voidable. If the party whose consent was so caused had the meaning of discovering the truth with ordinary diligence, means if I put ordinary efforts I can discover the truth, so it is not voidable. A fraud or misrepresentation which did not cause the consent to a contract of the party on whom such a fraud was practiced or to whom such misrepresentation was made does not render a contract voidable. So, fraud or misrepresentation did not cause the consent of the party on which fraud was practiced, so it is not render a contract voidable. When consent to an agreement is caused by undue influence, the contract is contract voidable at the option of whose consent was so caused. Any such contract may be set aside either absolutely or if the party who is entitled to avoid it has received any benefit thereunder upon such terms and condition as the court may seem justice. A contract is not voidable merely because it was caused by one of the parties to it being under mistake as to matter of fact. Unilateral mistake of fact is not voidable. Competence of the parties. Every person is a competent to contract who is of the age of majority according to the law of which he is subject and who is of sound mind and is not disqualified from the contracting by any law to which he is subject. Accordingly, there may be three categories which are not competent to enter. First, who have not attained majority, person of unsound mind, person who are disqualified by the law, that is insolvent, convicted. Who has attained majority for according to Indian Godship Act, that is 21, and Normal Act, Majority Act is 18. Who is person of sound mind? A person is said to be sound mind for the purpose of making contract if at the time of when he is making a contract he is capable to understand, okay, and majorly he'll be of unsound, and normal time majority he will be sound mind, then also he will be sound mind, but if reverse is he is not qualified. Who are disqualified? Alien enemies. A person who is not an Indian citizen is an alien. An alien may be either an alien friend or a foreigner whose sovereign or state is at peace with India, has usually contractual capacity of a citizen on the declaration of. So, there is a contract between two people outside India and in India, and suddenly got a war declared between these two countries. So, alien enemy. Foreign sovereigns or ambassadors. Foreign sovereigns accredited representative of foreign states, ambassadors, high commissioner enjoy special privilege in that they cannot be sued in Indian courts unless they have voluntarily submit the jurisdiction of Indian courts. Foreign sovereigns government can enter into contracts through agent residing in India. In such cases, the agent becomes personally liable for performance of the contract. Oath Land Revenue Act provides that where a person is a oath is declared as disqualified proprietor under the act, he is incompetent to alienate his property. Valid consideration. Essentials of valid consideration. Consideration is when at the desire of the promisor, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or abstain from doing something, such act or absistence of or promise is called a consideration for the promise. So consideration can become from promisee or any other also. Essentials. Consideration should be at the desire of the person making promise. He may be offerer or the offeree, the promisee or any other person on his or her behalf, done, abstained, okay. So promisee or any other also okay. It is not demanding only promisee should make the payment, any other person also okay. It should be noted that English law consideration must move from the promisee so that the stranger to the consideration cannot sue the contract, but according to Indian law, consideration may move from the stranger as well. Privity of consideration. Privity of consideration is not strictly applicable. It means that the consideration may be paid by the parties or any other person. The doctrine of privity of contract provides that a contract cannot confer rights or imposes obligations upon any person who is not a party of the contract. So, in between parties can sue. Privity other than the contracting parties, other cannot sue. It is applicable in India with certain exceptions. Rules governing consideration. Every contract must be supported by valuable consideration. If no, void. Consideration may be by act or absistence or promise. There must be mutuality, that is, each party must do or agree to do something. Consideration must be real, not vague, indefinite, illusory. Although consideration must have some value, it need not be adequate. Consideration must be lawful. If the consideration is unlawful, the agreement is void. Consideration must be something more than the promisee is already bound to do. Exception to consideration. Section 25A, love and affection. An agreement may be made without the consideration, but it is valid in these circumstances. Normally, an agreement without consideration is void, but these are the exception to the consideration. It is expressed in writing and registered under the law for the time being in force. The registration of document and is made on account of natural love and affection between the parties standing in a near relationship. It is a promise or promise to compensate whole or part a person who has already voluntarily done something. It is a promise made in writing and signed by the parties to be charged therewith, the agent generally or specifically authorized in that behalf to pay the whole or debt of which creditor might have enforced payment, but for the law of limitation of suits, means time barred debt if they are making. Lawful object. It is forbidden. These are the consideration or object of an agreement is lawful unless it is forbidden by law, is of such nature that if permitted would defeat the provision of any law, is fraudulent, involves, implies injury to person or property. The court regards it as immoral or opposed to public policy. In each of these cases, the consideration or object of an agreement is said to be unlawful, and every agreement of which is object or consideration unlawful is void. Rules governing the consideration. Every contract must be supported by valuable consideration, otherwise it is formally void. Consideration may be act or absistence or promise. There must be mutuality. Consideration must be real, not vague. Although consideration must have some value, it need not be adequate. Consideration must be lawful. If consideration is unlawful, it is void. Consideration must be something more than the promisee is already bound to do for the promiser. Exceptions already read. This again I have repeated. And next, lawful object. That also done. And next, agreements not declare void. The following types of agreements are void under Indian Contract Act. Agreement by or with a minor. So, agreement by or with a minor or a person on settlement is disqualified to enter. And agreements made under a mistake of fact material to the agreement on the part, void. And an agreement of which consideration or mistake of fact is void if that mistake is very much material to both the parties or one of the parties, and an agreement of which the consideration or object is unlawful. Any part of a single consideration or one or more objects, or any of one or any of the any one several consideration for a single object is unlawful. So consideration is unlawful. An agreement made without consideration is void, but section 25 exceptions is in. For that, agreement without consideration is valid. An agreement in restraint of the marriage, an agreement in restraint of the trade, an agreement in restraint of a legal proceedings, agreement that the meaning which is not certain, capable of and not capable of being made in certain. Contingent contract, according to 31 of ICA, contingent contract is a contract to do or not to do something if some event collateral to such contract does or does not happen. Another contract to pay Brajesh 2 lakh if Brajesh will construct a house within 1 month. This is a contingent contract. The payment will be depend on the Brajesh being construct the house within 1 month. If he cannot, no required to pay. Next part B, specific relief act. Specific relief, recovery of specific immovable property. According to section 5, a person entitled to possession of specific immovable property may recover it in the manner provided under the CPC. Therefore, a civil suit may be filed by a party for recovering the possession of immovable property. Section 6 provides that provisions related to suit by a person disposed of immovable property. So there is a person who is dispossessed from his immovable property. It says that if any person is dispossessed without his consent of the immovable property, otherwise than in due course of the law, or he or any person through whom he has been dispossession, or any person claiming through him may be by suit recover possession thereof, notwithstanding anything any other title that he may set up in such a suit. No suit under section 6 short can be asked after the expiry of 6 months from the date of dispossession or against the government. So still 6 months you have been quiet. Now why you are suddenly asking? Now also stay quiet. Appeal or review is not allowed for any order or decree passed in the suit. Okay. However, suit to establish his title to such property and recover possession thereof is not barred. Recover of specific immovable property, section 7 and 8. According to section 7, a person entitled to possession of specific movable property may recover it in the manner provided under CPC. The provision is similar to section of Specific Relief Act, which provides for the provision of immovable property, means same as 6. But there are 2 exceptions, like a trustee may sue for the possession of movable property to the beneficial interest in which the person for whom he is trustee entitled. Special or temporary right to the present possession of movable is sufficient to support the section 7. Section 8 provides liability of a person in possession not as a owner to deliver the person entitled to immediate, means I took for a rent, so I have to give it back. It provides that any person having the possession or control of a particular article of rent of like dress, you think, article of a movable or of which he is not the owner, may be compelled specifically to deliver it back to the person entitled to his immediate possession on the following cases. First, when the thing claimed is held by the defendant as the agent or trustee of the plaintiff. When the compensation in money would not afford the plaintiff adequate relief for this loss. So the law itself here specific relief. So I want specific relief. I don't want cash or monetary. When it would be extremely difficult to ascertain the actual damage caused, and when the possession of a thing claimed has wrongfully transferred from the plaintiff. A specific performance of contract of part performance. Where any relief is claimed in respect of a contract, the person against whom the relief is claimed may plead by way of defense any ground which is available to him under any law relating to contract. Thus, the specific performance of a contract are enforceable by court subject to provisions of 14 and 16. Except as otherwise, the specific performance of a contract is enforceable when the act agreed to be done in the performance wholly or partly of a trust. The court may direct the specific performance of a part of a contract only as per the provisions provided under section 12 of Specific Relief Act. Where a party to a contract is unable to perform the whole or part, but the part which be left unperformed be a only small proportion to the whole in value and admits the compensation in money, the court may at the suit direct the specific performance of so much of conduct that can be performed and award the compensation in money for the deficiency. Only small part is left, so take compensation and leave. Substantial part, where a party to a contract is unable to perform the whole of his part, and the part which left unperformed is either forms a considerable part, means material part of the whole, though admitting of compensation in money, or does not admit a compensation in money, he is not entitled to obtain a decree for specific performance, but the court may at the suit of other party direct the other party to in default to perform specifically so much of his part he can perform. If the other party, in case falling under clause, pays or has paid the agreed consideration reduced by the consideration for part left unperformed, pays or paid the consideration for the whole, means if possible to do, if not then money. When a part of a contract which taken by itself can and ought be specifically performed stands on separate and independent footing from another of the same which cannot be or ought not to be performed, the court may direct to perform such of the former part. Means there are two parts, one can be performed, one cannot be performed, so perform the part which you can perform, the rest you can pay the money. Rights of the purchaser or lessee against person with no title or imperfect title. Section 13 of SRA enumerates the right of a purchaser or lessee as under, where a person contract to sell or let certain immovable property having no title or only imperfect title, the purchaser or lessee may compel him to make the good the contract out of such interest. So you gave the imperfect, now make it perfect, make good. Where the concurrence of other person is necessary for validating the title, they are bound to concur at the request of vendor or lessor. The purchaser or lessee may compel him to procure such concurrence, and when a conveyance by other person is necessary to validate the title, and they are bound to convey at the request of the vendor or lessor, the purchaser or lessee may compel him to procure such conveyance. Where the vendor professes to sell encumbered property, but the property is mortgaged for an amount not exceed the purchase money, and the vendor has in fact only right to redeem it, the purchaser may compel him to redeem the mortgage and obtain a valid discharge, and where necessary also a conveyance from the mortgagee. Like there is a draft of reconveyancing of mortgage, so all the money has been settled, so now I am reconveying, so I am giving back your property to you, like that. Where the vendor or lessor sues for specific performance of the contract, and suit is dismissed on the ground that of his want of title or imperfect title, the defendant has a right to return of his deposit, if any, with the interest thereon. So he has to return with the interest and deposit to his cost of the suit, and to lien for such deposit interest cost on the interest, if any. This provision also applicable to contract for the sale or hire of movable property. Contract not specifically enforceable, so can take only damages. First, where a party to contract has obtained the substituted performance A to be obtained, but instead of performance A I got performance B, so already substituted is done, then no specific sue. A contract the performance of which involves performance of a continuous duty which the court cannot supervise. Continuous duty, like milk, everyday milk will be given, so everyday court cannot supervise, that also take damages and leave. And a contract which is so dependent on a personal qualification of the parties that the court cannot enforce specific performance of its material terms, so personal qualifications is there and the person is not ready to perform, so court also cannot do. A contract which is in the nature of determinable. Next, who may obtain specific performance? Any party thereto, representative in interest, whether contract is a settlement on marriage, a compromise of a doubtful rights between members of the same family, or any beneficiary entitled, where a contract has been entered between a tenant for the life in due exercise of power, the remainder man, a reversioner in possession, where the agreement is a covenant entered into with the predecessor in the title and reversioner entitled to benefit. A reversioner in remainder. First one is reversioner in possession, means at last you will get the possession. Reversioner in remainder, where the agreement is such a covenant, the reversioner is entitled to the benefit thereof and will sustain material injury by such reason or its breach. When a LLP has entered into contract and subsequently becomes amalgamated with another NLP, the new LLP which arises out of amalgamation should do the act which old LLP has promised to do. When a company has entered into contract and subsequently becomes amalgamated, so the new company has to do. When the promoters of a company have before its incorporation entered into contract for the purpose of the company and such contract is warranted by the terms of the incorporation, the company, provided that the company has accepted the contract and has communicated such acceptance, non-availability of specific performance of a contract in favor of certain persons. Section 16. Same repeated already here. Contract to sell, similar to section 13. Or let property by one who has no title not specifically enforceable, who knowingly himself not to have title property has contracted to sell, who though he entered into contract believing that he had a good title, the property have a good title, cannot at the time fixed by the parties court for the completion of the sale or letting give purchase or lessee free from the reasonable doubt, non-enforceable except with a variation. Means there is a contract that cannot be enforceable, but if any variations have been made, can enforce. Relief against parties and persons claiming under the subsequent title, either parties, any other parties claiming under him by a title, and any person claiming under a title which, though prior to contract and known to the plaintiff, might have been displaced by the defendant. Substituted performance, power to award the compensation in certain cases. Next, declaratory decrees. Means only it will just declare the rights. It will just declare the who is any person entitled to a legal character or to any rights to any property may institute a suit any person denying or interest deny his title to such character or right, and the court may in its discretionary make therein declaration that he is so entitled and plaintiff need not such suit for asking. So there is a right which available to me, but I am not getting it. So by filing the case, I can get a declaratory decree in favor of me that court is declaring that that right belong to me, so other person who is stopping, they cannot stop me more. Next, TOPA. Sale. How is what is sale? According to section, it is a transfer of ownership in exchange for a price paid or promised or part paid or part promised. So price part paid, promise part promised. In order a document to be treated as sale document, ownership must be transferred from one person to another, and the transaction must be supported by a consideration paid or promised to pay. And how sale is affected primarily deals with the transfer of immovable. Primarily means even with movable also it will deal. A transfer of property may be affected in two ways. When the value of property is equal to or more than 100, and where the value is less than ₹100. Value of equal to 100 or more, such transfer in case tangible immovable property 100 or upwards, or in the case of a reversion of or other intangible thing, can be made only by a registered instrument. So for this only registered instrument, and less than 100 means unregistered also okay. Contract for sale. A contract for sale of immovable property is a contract that sale of such property shall take place on terms settled between the parties. It does not of itself create any interest on charge or mortgage already we know. The transferor is called the mortgager and transferee is called the mortgagee. Mortgage is defined as a transfer of an interest in specific in specific immobile for the purpose of securing a payment of money advanced or to be advanced by way of loan, an existing or future debt, or the performance of an engagement which may arise to pecuniary liability. Types of mortgages: simple mortgage by conditional sale, use of fractory mortgage, English mortgage by deposit of title deeds, anomalous mortgage. Lease and license: lease of immobile property is a transfer of right to enjoy. Lease is right to enjoy such property made for certain time, express or implied, on or in perpetuity, in consideration for the price paid or promised share of a crop service transferee who accept the transfer of such terms. Difference between lease and license once go through. A license is a right. So car license, that is also right to drive the car, that's all, like that only. License is a right to do or continue to do upon the immobile property of the grantor, something which would be in the absence of such right is unlawful. A license does not transfer any interest. Lease will transfer interest in the property. If lease transferred means can enjoy the rights attached to it. If interest is not transferred, then cannot enjoy the property. Only should have the right to use the property, that's all. And gift, onerous gift means with burden, like I am gifting shares for you, but I have paid only 80 rupees and rest 20 you have to pay. So to accept this, you have to pay 20 rupees. So either you can accept in full or reject full. Only benefit you cannot accept. Onerous means burdensome. And in the registration they gave like list of the documents which require compulsory registration and exemption from section 17. That is, these are not compulsorily required registration, but it is good if they get registered. And documents of which registration is optional. So first one was mandatory, they have to, and exception to have mandatory is before we read that. And documents of which registration is optional is section 18. And time and place of registration, if in immobile, the place where it is registered or the parties, and place of registration. Okay. Effects of registration and non-registration. Registration means valid title will be, legally recognition will be, and can sue and be sued and use as evidence. Non-registration, these all will be not there. Indian Stamp Act, instrument chargeable with duty, section 3. And at last, power of attorney. Done.